Okay, I've begun the recording. I think we've got a pretty good group of people. I can still see some people are coming in, but I think we can get started. Welcome everyone to this is the final installment of this semester or this term here at U of T for the Tort Law and Social Equality Speaker Series before we break for the summer and then resume in the fall. And towards the end of the talk, as I close things up, I'll give a bit of a preview about what we have coming up starting in September. Today, it's my pleasure to introduce our speakers, Hanoch Dagan Avihay Dorfman. Hanoch is the founding director of the Berkeley Center for Private Law Theory. Before that, he taught at Tel Aviv University Faculty of Law, and Avihay is currently a professor at Tel Aviv. Between them, Hanoch and Avihay have written on all areas of private law and private law theory. They each have an extensive list of publications on these subjects, basically in every leading law review you can name, and every leading publishing house that you can name. What is especially relevant, I think, for this speaker series is that in recent years and over a series of publications, they've developed an innovative theory of private law that revolves around the concept of what they call relational justice. And this theory aims to update our understanding of private law and show how matters of social justice should be of central concern for it rather than peripheral. And so it's kind of right on point for the Tort Law and Social Equality Project Speaker Series. We're very lucky to hear from them today. They're also currently writing a book that ties together their views on relational justice. They're going to be applying their distinctive theory today in their talk on the value of personal rights of action. So Hanoch and Avihay, as you know, 45 minutes for your presentation, roughly, and then after that, we will have a Q&A. Thank you so much, and over to you.
Oh, so thank you, Anthony, for the invitation, and thank you all for joining us today. So this is a joint project of Hanoch and myself with our Tel Aviv colleague, Itzi Rosenzvi, who is a civil procedure guy. So you should blame him for all the mistakes we are making on civil procedure, at least. To set the scene, it will be up to situate our argument in the kind of broader analytical framework of rights in private law. It is helpful to distinguish, I think, between three different types or kinds of right. There is the primary or substantive right, such as right to bodily integrity, reputation, property, so forth. Then there is a secondary right, which is often called the right of repair. It entitles holders of primary rights redress or rectification for the consequences of violating their primary rights. And finally, there is a tertiary right, which is a kind of a third order right to seek or obtain redress. Rights of action are the most, I think, familiar instantiation of tertiary rights. It's a legal mechanism by which victims of wrongs can pursue those who violated their primary rights. Now, there are many important questions to ask about the relationship between the three types of rights, right? About their nature, about the kind of grounds. We generally argue for the normative priority of primary rights over the other two, in the sense that the former, that is primary rights, are the grounds for the latter two. But saying this much doesn't exhaust the case for rights of action. So the question we ask in the paper is, what is the normative status of rights of action? And in particular, are they merely subservient to secondary and primary rights, or can they have their own freestanding value? There are, I think, theoretical, policy, and doctrinal implications for asking this question. So just to take an example from the kind of policy plane, the case for and against tort reforms and other legislative attempts to curtail or weaken rights of action depends in some measure on this question. So one clarification will be up before I will outline the main themes of the argument. It concerns the scope of the argument. So private persons may hold different kinds of rights of action. We focus only on what we call personal rights of action, and we define them as rights of action that are granted to private persons in virtue of being a victim of a wrong committed by another private person rather than by the state. So we therefore set to one side the case of enforcing laws and advancing public policy by placing a private person in a de facto position of a private attorney general. Those kind of rights are out of our, are not in our attention in this paper. Contemporary private law theory, at least those who do consider personal rights of action as part of the domain of private law theory, tend to defend a somewhat, I would say, either simplistic or simple approach. So personal rights of action are either fundamental or even normatively necessary. I think this is a civil recourse approach, or they are purely instrumental. John Gardner's book on From Personal Life to Private Law comes to mind, Economic Analysis of Law. And some of the instrumentalists even go further by saying that, I think David Rosenberg of Harvard would be an example, that personal rights of action are even a deficient mechanism, and we should just abolish them and make something different. So, and the point here, and this is a kind of our first intervention in the discourse, is that both approaches, both the kind of non-instrumentalist and the instrumentalist, proceed indiscriminately to defend their restrictions with respect to all rights of action in tort law and perhaps private law more generally. So it's an either or. It's either you're non-instrumentalist about everything or you're instrumentalist about everything. We find that counterintuitive and ultimately wrong. To be more specific, let's grant it, for the sake of this talk, that the victim of a tort is entitled to obtain material redress from the wrongdoer. This entitlement, this is the secondary right of repair in this analytical grid that I've laid out in the beginning. This entitlement leaves open the question of how, that is, in what ways and to what extent, it should be brought about. Indeed, it is one thing to insist on the victim's entitlement to benefit from material redress, quite another to say that the victim should be the agent of such redress. The traditional common law model of personal rights of action is certainly a means, that is a legal technology, to bringing about material redress, but it is not the only one. And to close this gap, we need a normative gap, again, to be sure. We need an account not merely of why remediation, restoration matters, but also why victim-led restoration matters. In particular, we wish to understand why, and even more so when, personal rights of action are integral to vindicating the victim's substantive rights. We believe that contemporary tort theory does not answer this question. Furthermore, and for the most part, it does not have the normative resources to answer it in a satisfactory manner, that is, to answer the when question, that is, when personal rights of action are integral. So our answer to this question is that sometimes rights of action can be non-instrumentally valuable, but unlike, let's say, civil recourse and others, we take seriously the qualified language in which it is framed, sometimes, but not always, and not even typically. So we don't think it is plausible to hold that all personal rights of action are non-instrumentally valuable. And just to render this more vividly, this intuition, consider a case of a manufacturer of a defective product causing property damage to the product's user. Now, compare it with a case of deliberate sexual harassment. Are the right to seek material redress in this case of product liability and the right to pursue a perpetrator in a sexual harassment case different applications of the same moral commitment or idea? We think not. So in the paper, we identify two categories of cases in which personal rights of action have non-instrumental value. One category is deliberate wrongdoing, and the other is what we call relational wrongdoing. This is a term of art, as you will see in a moment. Because our argument is grounded in our theory of relational justice, it will be up to first outline the main themes of this theory and then unpack the two categories in more detail. Just as an aside, and following on Anthony's announcement, we are happy to share with you that our book on relational justice will be out this coming summer, but the paper that we present today is not part, or at least not all the paper is part of the book, so there is more to come. So here is a brief outline of relational justice. Relational justice articulates the normative foundations of private law in a liberal legal order. Private law governs daily interaction between private persons in a variety of settings in which people encounter one another as private persons. It's about the road, the neighborhood, the workplace, the market, and more. It does the governing by constructing terms of interaction, such as duties of care. Relational justice addresses the question of what terms of interpersonal interactions count as just, not only at the remedial stage, but also, and more importantly, at the get-go stage, which means that private law has a constructive ambition. There are two basic elements in how relational justice approaches private law terms of interaction, how it does the construction. The first concerns the relational form of these terms. So relational justice assesses their justice, the justness of the terms, by focusing on whether the participants relate to one another as free and equal persons. Relational justice treats the terms of interpersonal interaction as a source of concern and value in and of itself, as opposed to a means or a way station to maximizing overall social welfare or reducing distributive injustice in society. The second element is substantive, as it delves into what it means for the interacting parties to relate as free and equal persons. On the relational justice framework, private law terms of interaction should abide by the fundamental liberal maxim of reciprocal respect for self-determination and substantive equality. It means that these terms do not stop at safeguarding the independence or negative liberty of either party, nor do they concern themselves with treating the parties as formally equal, that is, as equal simply by virtue of having a generic capacity for choice. Rather, relational justice insists on terms that reflect a capacious vision of self-determination or autonomy. It is also not content with formal equality, but aims at establishing substantive equality by taking, rather than ignoring, the interests and vulnerabilities of the interacting parties into account. So by implication, elevated duties and responsibilities need not, and sometimes must not, turn on voluntary undertaking. Instead, they can, and sometimes must, arise by operation of law, reflecting the demands of relational justice. As we show elsewhere, there are many different numerous doctrines of private law that are straightforward manifestation of relational justice, commitment to self-determination and substantive equality. But this paper focuses on the case of the non-instrumental value of rights of action, why they might matter beyond their contribution to securing material redress. So the first category of cases is concerns with deliberate wrongdoing. So among the many different types of wrongs that make up the law of torts, some types feature an additional or parasitic dimension of wrongfulness triggered by the illicit behavior of the wrongdoer. So for instance, the one who deliberately attacks an innocent victim is not only harming the person of the victim, but rather also intends, in a sense of means, this much. Unlike the case of inadvertently causing serious bodily harm, the deliberate wrongdoer also executes a plan to inflict such harm. So we argue that a wrong deliberately done can constitute a second parasitic wrong to autonomy. Material redress does not provide an adequate response to the latter. Personal rights of action, by contrast, provide a fitting response. So to flesh out the dual nature of deliberate wrongdoing, consider the contrast between deliberate and accidental wrongdoing. Imagine a case in which both forms of wrongdoing result in the exact same serious physical injury. Okay, so the bottom line is just the same. On the deliberate end, a person intentionally strikes another in the eye, and a similar injury occurs when a person seeking to separate two fighting dogs raises a stick over his shoulder, accidentally striking a person standing closely behind him in the eye. Of course, this rings familiar. The facts are taken from Brown versus Kendall, the famous Massachusetts 1850 case. We argue that despite the identical bottom line of serious injury, the two instances represent substantively different forms of interpersonal mistreatment. This is because the deliberate way of harm is perpetrated gives rise to another wrong, which is that of subordinating the victim to the pursuit of one's own ends. We use subordination to express the intentional singling out of a person for mistreatment. It involves the identification of a particular person, the would-be victim, as the object of the misconduct, and thus represents the total reduction of that person into a mere instrument at the hands of the injurer. Carelessness or accidental wrongdoing, by contrast, does not entertain this special subordinating character just mentioned. Its harmful outcome can be reasonably foreseeable, of course, but save for acting with knowledge to a substantial certainty that his conduct would strike another person in the eye, the outcome is just accidental, a failure of inattention or some such. It might ground liability for the resulting injury, to be sure. However, it involves nothing by way of acquiring intentions and making a choice in favor of singling out the victim of the careless act. Thus, in deliberately striking another in the eye, the injurer is also wronging the victim by undermining her autonomous being. To understand the nature of this setback, it will be apt to emphasize its two basic aspects or elements. First, the setback to the victim is substantive as opposed to superficial. It does not merely threaten to thwart this or that plane of the victim, say to safely cross the street, but rather seeks to deny the victim the very status of an autonomous agent who is entitled to decide what plans to make in the first place. The second element is that the setback to the victim's autonomous being also has an irreducibly relational dimension. This is because autonomy is not only a relationship between a person and the choices he or she makes, but also a relationship between that person and others. In particular, the significance of autonomy is in part given by an interpersonal element, that being autonomous requires that others treat us in a certain way, namely as self-determining agents who are thereby entitled to write their life stories. Deliberately striking an innocent person in the eye brings out the relational dimension of autonomy, as it reflects the active rejection on the part of one person, which is the injurer, of the very idea of another person as an autonomous being. Against this backdrop, we can return to the basic question: why having the right to sue the deliberate wrongdoer, quite apart from the right to material redress, might matter to the victim? The answer is that although material redress could be a fitting response to the physical injury from which the victim suffers, it does not fully address the setback to his or her autonomy. Simply put, material redress, absent a personal right of action, may leave intact the relational aspect of the setback to the victim's autonomy. So adequate material redress can include compensatory and even super compensatory damages, including even punitive damages, but ultimately the victim has a right to receive a check that reflects the full monetary value of the injury's adverse consequences. However, securing this right to material redress by compelling the injurer to pay damages ex post facto may not make good on the deliberate rejection of the status of the victim as an autonomous being. What is also required is an institutional framework that provides the victim with the facility to reassert his or her autonomous status, not necessarily in general against the world at large, but rather against the injurer in particular. To see this, consider why punitive damages, I think that's the kind of challenging case, why punitive damages may fall short of furnishing a fitting response to the deliberate wrongdoing at issue. So an award of punitive damages can never prevent the injurer from running his or her deliberate plan of rejecting the status of the victim as an autonomous being, nor, more importantly, can it force the injurer to treat the victim as an autonomous agent at the remedial stage. At most, it forces the injurer to deal with the victim as a beneficiary of a right to material redress. It turns out that the deliberate disregard of the victim's autonomy remains a going concern for the terms of interaction between the two, even as the victim receives a hefty award of punitive damages. Can there be a way for the victim of deliberate wrongdoing to reassert his or her status as an autonomous person? So looking from the other side, we can ask another question. Can there be a way to compel the injurer to interact with the victim at the post-wrong stage on terms that secure the status of the latter as an autonomous person? The answer to both questions lies in granting personal rights of action on top of rights to material redress. So such rights construct terms of interaction under which victims are entitled to reassert their autonomy vis-a-vis their injurers. In that, personal rights of actions are not only a means to the end of material redress, but rather also valuable as such, quite apart from whether they are the best legal technology to secure adequate material redress. So to be sure, talk of personal rights of action should not be confused with stronger powers and entitlements. And this is a way for us to kind of distance ourselves from some of the other who make similar arguments in the literature. In saying that victims of deliberate wrongdoing should have a right to sue their injurer for material redress, we reject the familiar claims often made by civil recourse theorists and others that this is a right to hold the injurer accountable or responsible. In fact, we think courts, rather than plaintiffs as litigants, hold a special political authority to do that. If anything, victims can get some power in the direction of holding the injurers accountable or responsible only after and only insofar as they win their case, as when they seek to collect the damages awarded them or some such. So instead, we argue that personal rights of action, in addition to triggering a process leading up to material redress, they also construct terms of victim-injurer interactions wherein the former gets to reassert her agency or autonomy vis-a-vis the latter. Reasserting one's agency as against the injurer consists of two elements. Today, everything comes in two. The first is waivability. The victim alone gets to decide whether to pursue the injurer. So the victim manifests his or her autonomous agency as against the injurer by determining how a past wrong should reflect on his or her life going forward. At times, leaving it behind may be the right thing to do purely for instrumental reasons concerning time, energy, reluctance to invoke the adversarial tort system, or for non-instrumental reasons stemming from the victim's deep commitments, say to forgiveness, mercifulness, or some such. At other times, refusing to lump it may better resonate with the victim's effort to rewrite his or her life story in response to being deliberately wronged by another. So a right to sue the injurer is a legal instantiation of this course of action, captured under the idea of waivability. Now, let's get to the second element, suing the injurer. Suppose that the plaintiff decides to pursue the injurer. Suing the injurer can construct an interpersonal engagement wherein the victim reasserts his or her autonomous agency as against the latter. The engagement is structured around two key layers, again, two, an epistemic and an evaluative one. On the epistemic front, the two parties make often competing claims concerning the facts of the matter, ultimately allowing the fact finder to establish who did what. In this way, either party in the lawsuit is implicated in a process of responding to the factual claims made by the other, in the sense that each party's factual claim is in a way a response to, or anticipation in response to, what the other party has claimed. It is precisely in this respect that the two can come to deal with each other as constituting their own point of view and ultimately autonomous being. The second layer, the substantive one of this engagement, occurs when they determine, or the courts determine who did what. After determining who did what, the factual stage, then we ask the question, the normative, the substantive question of what either party should have done or refrained from doing. The inquiry on this front addresses standards of behavior and assesses the actual conduct of either party in the light of these standards. Here too, the lawsuit implicates the parties in a process of making claims in response to those who made by the other. Responsiveness gets the parties closer to vindicating the setback to the victim's autonomy. This is the post-wrong stage in which the parties confront head-on the difference between, among other things, mistreating the victim by inadvertently causing harm and by deliberately rejecting his or her status as an autonomous being. The parties can agree or disagree on how either party should have acted, but there is no denying that the injurer, now acting as a defendant, is required to recognize and make evaluative claims based on their recognition that the plaintiff is an autonomous person. So to conclude this part, whether or not suing the injury is the most effective means to securing the end of material redress, a personal right of action can provide a fitting response to the setback to the victim's autonomy caused by the deliberate wrongdoer. Now let's move to the second category of cases in which we think there is non-instrumental value in having personal rights of action, which is the relational wrongdoing. So this other form of wrongdoing calls for a personal right of action, concern itself with the impairment of a special relationship of a certain character. It features first a relation of dependency that second plays a substantial role in the life of the victim. For example, we discuss employment, landlord-tenant, and parent-child relationships. Relational wrongdoing has a distinctive property. The wrongdoer not only harms the person or property of the victim, but also impairs the relationally just terms of interaction between the two. The latter setback reflects the additional or parasitical wrong that makes up what we call relational wrongdoing. The suing enables the victim not only to obtain material redress, but also to reassert her equal standing with respect to the defendant with whom she stands in this special relationship. Notice that the fact that a particular relationship is asymmetrically structured, as let's say in employment relationships, does not mean that its justness should not be assessed by reference to a standard of transactional equality. In fact, we believe that a commitment to substantive equality explains why dependency should give rise to elevated responsibility and duties on the part of the more powerful party in this relationship. So an employment relationship may count as egalitarian in the sense that its terms of interaction take the power imbalance between the parties seriously, only if employers bear responsibility to the safety of the employees, and moreover, if the amount of such responsibility is commensurate in some way with the level of dependency of the latter on the former. Relational wrongdoing concerns the subjection of the victim of a wrong to inegalitarian terms of interaction between those who already stand in a certain relationship of dependency. It undermines victims' interest in an egalitarian relationship on top of setting back their interest in physical safety. So let's just take an example. A case of sexual harassment at the workplace can illustrate what relational wrongdoing might mean. So consider an employee who is subject to a series of offensive touchings by her co-worker. Among other things, and setting to one side the wrong directly inflicted by the harasser, the co-worker, the victim can also complain that the employer wronged her by failing to provide a safe workplace. Further, suppose that unlike the injurer who deliberately strikes another in the eye, the employer's failure is one of negligence, reflecting want of due care. The victim may be entitled to recover for the resulting dignitary, physical, and emotional harms she suffered under, and among other things, common law theories of negligence and statutory schemes of worker compensation. To this extent, material redress might be a fitting response to all the adverse consequences brought about by the wrongful actions of the employer. Again, setting aside the other direct wrongdoing. That said, the employer wrongs the victim in another way as well, rendering insufficient the right to material redress. The tortious conduct at issue also impairs the parties' ongoing interaction by placing the employee under inegalitarian terms of employment relationship. More specifically, the employee becomes vulnerable due to the employer's deficient responsibility for her safety. By giving effect to terms of interaction between co-workers that place the would-be harasser in a position of power with respect to the bodily integrity of his victim, the employer fails to deal with the employee, the victim, as a free and equal person. So to render this analysis vivid, consider the difference between this case of sexual harassment at the workplace, and instances of sexual harassment where the parties are mere strangers, okay, out of any kind of familiar context. We do not say that sexual harassment between strangers is less or more offensive or devastating, of course. Nor does it mean that an act of sexual harassment that occurs out of an important context for the victim is less culpable. Rather, the relational context in question, consisting again in dependency and importance, opens another dimension of injury from which the victim can suffer, namely an impairment of an ongoing relationship of the relevant kind. We argue that the work context, and like other contexts we discussed in our work, features the two significant elements that are jointly necessary for the impairment of a relationship to constitute relational wrongdoing, that is, structural dependency and intrinsic importance. Dependency refers here to the normative and economic manifestation of power imbalance associated with typical employment relationship. The limited authority of what it means is that the limited authority of employers over their employees and their relatively better access to capital, resources, and means of production. By importance or intrinsic importance, we mean that work captures a significant role in the life of free and equal persons. For this, work can be a grand project, which thereby gives a meaning to their life. So against this backdrop, we argue that material redress, including punitive damages, falls short of repairing the setback to the relationship between the victim and the employer. Material redress could make it more likely that, going forward, the terms of employment relationship will be better enforced, but it cannot set right the already impaired relationship between the two. It leaves intact the past objection of the victim to inegalitarian, perhaps even oppressive, terms of interaction with both other co-workers and the employer himself or herself. To properly address her relational predicament, the victim should be able to reassert her equal standing, that is, her entitlement to having been treated as an equal by her employer. Treating her as an equal means that the employer should have exercised the quality and quantity of care reflecting his employees' vulnerability to workplace harassment, among other safety concerns, of course. As in the case of manifesting one's agency in relation to deliberate wrongdoer, reasserting her equal standing begins with granting the victim, the employee, the right to decide, this is the waivability condition, the right to decide whether to sue the employer for failing to provide a reasonably safe workplace environment. It further means that if she so decides, the victim should have a right to confront him, the employer, under terms that reflect their equal standing. So a personal right of action can give rise to such terms by entitling the victim to make epistemic and evaluative claims against her employment, and in this way to reassert her status as equal person, not merely vis-a-vis society as a whole, but rather in relation to him in particular. So there are many different implications for our argument. Let me just emphasize one. I think there are few more minutes. So let me just emphasize one, which is the kind of question of, does our argument fit with current tort law? And so what changes would be needed in order to create a better fit between our account and current tort law? So start with deliberate. So let's split between deliberate and a relational wrongdoing. So with respect to deliberate wrongdoing, the significance of the distinction between deliberate and non-deliberate wrongdoing to the question of why and when rights of action should be made personal finds its expression in modern tort law, or at least some expression. Most importantly, some of the most comprehensive statutory tort reforms of the 20th century, such as worker compensation schemes in the US and the New Zealand tort reform, have abolished or significantly weakened personal rights of action of tort victims. For the most part, however, these reforms entitle victims of deliberate wrongdoing directly to pursue their injuries. In the case of worker compensation schemes, workers can sue their employers for deliberately inflicted work-related injuries. And in the New Zealand case, as far as I know, victims can personally sue to recover punitive damages or to secure injunctive relief for instances of wrongdoing that meet our definition of deliberate wrongdoing. Apart from these reforms, however, the law of torts does not make a consistent effort to distinguish between its various causes of action based on deliberate wrongdoing. So on the one hand, some torts do turn on the deliberate nature of the wrong. Think about intentional infliction of emotional distress in the US, the tort of fraud, defamation in the US, especially against public figures, are familiar cases in point. On the other hand, however, some veteran torts make no special reference to deliberate wrongdoing. So intentional torts such as battery and trespass to land give rise to causes of action that cut across the distinction between deliberate and non-deliberate wrongdoing. Now, let's move to relational wrongdoing. Existing causes of action, there the picture is much more grim from our perspective. Existing causes of action do not make explicit reference to the distinctive injury involved in relational wrongdoing. This is not to say that the value of an ongoing relationship between the plaintiff and the defendant plays no role in considering, for example, what tort duties are owed, what constitutes their breach, whether the defendant should be held liable, and what would be the proper remedy, such as awarding damages for loss of companionship, for example. But these concerns are directed at the question of material redress, whether the injurer owed a duty to the plaintiff, what its content, and so forth. What is left unaddressed is the freestanding concern for the additional injury, namely the impairment of a relationship of a special kind. So in the paper, we seek to explore this matter more directly by focusing on specific cases, on class actions, arbitration clause, and certain other doctrines that perhaps brings more vividly the tension or the distinction between the instrumental and the non-instrumental value of personal right of action. Before I end the presentation, I just want to note that we also discuss in the paper, or at least beginning to discuss also the democratic value of personal rights of action, and we argue, but this is kind of completely different set of arguments, but we argue that democracy can also ground a set of prescriptions concerning whether and when personal rights of action matter, including for non-instrumental reasons. And of course, we'll be happy to address also the democracy aspect of our arguments. So unless Hanoch has something to add, we'll be happy to take your questions. Thank you very much.
Indeed.
Thank you so much. And so I take it that Hanoch, you're ready to open it up for the Q&A as well. So I'll take a cue, starting with Stephen Patel and then Zoe Sanoff.
Thanks very much. Thanks for the presentation. Always a pleasure. You're suggesting, it seems to me, that a piece of civil litigation can accomplish certain things for the victim. And I'm wondering how the idea of settlement fits into what you allege comes from the civil litigation. Because it seems to me, I'm not even sure I'm going to agree with them, but even if I take what you say at face value that civil litigation provides, okay, if I'm a defendant and I did some wrong, so the plaintiff sues me and I say, screw you, I'm not engaging with you, I'm not putting competing factual narratives before you, I'm just writing you a check, right? You're suing me, I'll just write you a check, you're gone, forget it. The law does not allow you to continue suing me once I've made you whole, right? So in other words, there isn't an independent ability to keep suing me even though I've paid you, right? So once I pay you, I've eliminated whatever you are claiming flows from that piece of civil litigation. And so I wonder if that doesn't perhaps undercut some of the things you say flow from the civil litigation and therefore make civil litigation in response to certain wrongs an inherent requirement.
Yes. Okay, great question. So basically, I think you're right. At least in some jurisdictions, the defendant can just write a check and say, this is my check. I don't want to litigate this case. And in that way, the defendant turns his or her back against, the ideas of asserting the plaintiff's autonomy and so forth and so forth. So I think you're perfectly right that this may characterize the law, the civil procedure law in many places. So in the paper, we do spot this problem, which is a huge problem, I think, for people in civil recourse and certain other corners of private law. The way that we deal with that is that we think that our account gives the legal system a reason to change or to respond to that problem, right? One way to, and we leave it open because it really depends. There are different moving parts in every legal system, in every system of civil litigation, but there is a range of changes that we could implement in order to account for what you've just said. We can think about, and I think the most kind of minimal reaction would be, okay, you just write a check, so add an extra, an extra sum that would reflect the fact that you are turning your back against the plaintiff. Another, perhaps more appropriate reaction would be that you have a duty, an obligation, at least to appear in the court for the first meeting and just say, here is your check. But some kind of conduct should be required from the defendant in order exactly to account for this shortcoming. So we are with you on that, but we think that this all only gives rise to some reform in how we understand civil litigation, and this could be a good way to answer the question. Okay, so do we want this kind of burden to be imposed on all defendants? And our answer is no, only on defendants in cases of deliberate wrongdoing, relational wrongdoing, but not in other cases. Thank you.
Another way to, I think, put it, just in different words, is to, if we take your point all the way through, then it seems to buy fully into the instrumentalist position regarding civil litigation. And if some of us share some intuition that there is something wrong about that, then we need to come up with an account for why not go all the way instrumental. And that is where we settled up. And we actually debated and discussed this particular issue quite a bit, because again, if we take seriously some of the civil recourse and philosophical accounts of that come with it sometimes of Stephen Dawal, then it seems as if there should be an injunction against every defendant to fully litigate, right? And that, as you say, does not make any sense. So the initial intuition, actually, this paper came up from a book review that we've written on John and Ben's wonderful Recognizing Wrong. So, and the initial iteration on that was that we were taking kind of the more bullish position as saying that no, you're confusing. That the tertiary right is tertiary for a reason. It's not. It doesn't have any intrinsic significance. But we realize that it has, and the main issue, as Avihay started his presentation, is to refine when it has, and then indeed to try to think of how to address your question. So it's a really important one. I hope that the answer satisfies you. You have other suggestions of how we can actually have the cake and eat it too in this kind of very important corner case. It's sort of a corner, but it's really important. We'll be more than grateful.
Just to follow up on Hanoch's, on me, just to say that the ambition of our paper is not merely descriptive, right? So we don't think that what we are setting up here is an account that accounts for every detail in the law. So I think we may account for something, but our main ambition is normative, and we try to give a normative framework about how to think about the law, including how to change it when it ought to be changed.
Thanks, Zoe.
Great. Thank you so much. It was fascinating. So I just want to follow up quickly on what my colleague Stephen said about settlement, and it's just that you like say I break your window and you're like here's $100 and you shove it in my hand, I can still sue you, right? Unless you're accepting that settlement as a settlement of your legal rights. It could be the case I sue you, the court's like, what are you doing? They gave him $100, like, you know, they're like, oh, you like, that's all it was worth, nothing for you, and maybe they award costs against me. Okay, so I think that you can maybe deflect that way. Okay, but I have my major question has to do with this tripartite distinction of rights. And so here's what I take you as saying like, listen, some people say that some of this right of action is just instrumentally valuable because it helps you realize your primary right or helps you realize your secondary right. You're like, actually, sometimes this right of action is itself intrinsically valuable because of, so here's where I'm sort of like, how, if you see like the secondary remedial right as the way of redressing the primary right, so it within the secondary right is the primary right, and the tertiary right is the means that you have to redress the violation of the primary right, wouldn't that then, so you're saying in deliberate wrongdoing, there's something extra that's not caught, but wouldn't the primary right contain within it all those things that you were trying to accommodate? So isn't it always just instrumental on an account? If you were going to distinguish between different types of rights in this way, isn't it always the case that the tertiary right is instrumental with respect to things that are inherently valuable, perhaps that are contained already within the primary right? So here's another way to put this point. Like, so what happens? Actually, I'm not even sure. Like, who can violate my tertiary right? So if my tertiary right, my right of action to sue is something, I can imagine situations where this happens. Like, I think that cases like Whiten, like the contract case is a case where the insurance company was kind of violating in some way the right of action of the plaintiff to sue in an appropriate way. But like, who violates that right? And then we have another like three-part structure that happens again as well. And then if that one, like, so this is kind of like an infinite regress of like rights violations that will just go on and on and on. So I'm kind of trying to figure out the relationship between these. And then my third point is just a small point, is that I'm like not sure I understand what deliberate wrongdoing is in the context of tort. So I understand what intentional wrongdoing is, and I understand what wrongdoing that is committed through like negligence, unreasonable behavior that results in harm or damage. I understand what that is, but there isn't really a category of like deliberate wrongdoing, right? So when you have these, so the way you described it, I would understand that as crime, which also can be responded to through tort. And then that deliberate bit you get when you're like, yeah, you're subordinating me in a really despicable way. You've wronged me in a way that not only have you intended to do it, like as in you intended the consequences of your act, which is like what intention means in intentional torts, like, right? It's not, there's a thing like, and I meant to, but also I meant to wrong you, or I treated you as a sort of, well, then you get aggravated damages. And these are complicated, but you can tell a story wherein all of that is contained within secondary and the primary, right? If you're me, you think those are the same thing, right? But if you're other people, you can still tell that story. So I'm just wondering what this category of deliberate wrongdoing, it's just not really familiar to me in my understanding of tort law. But anyway, that's really, I've lots of thoughts. So thanks so much.
Okay, thank you. So with respect to the first point, I think you're referring to the repayment rule, right? I'm not. I think I've read Steve Smith. I think has a wonderful paper had a wonderful paper on Harvard Law Review about the repayment rule as a kind of his proof as to why violating primary rights does not give to a legal duty of repair. It's only when you sue and so forth. I think that the explanation for the repayment rule, the kind of example that you gave, I broke your window, now I could give you the money, but that does not work because I could still sue. I think the reason for why we have this repayment rule is mainly pragmatical, instrumental. We don't want people to fight. We don't want to increase this violence on the street. We want to channel people in this position to courts because in addition to a very kind of civilized way of solving the matter, as you just say, I could understand that there may be hundreds of other cases in which we would have some violence, and so I think the repayment rule addresses some kind of pragmatic concern. And by the way, this is a thing that I haven't thought about it, but Hanoch is the expert on this as between the two of us. I'm not sure that the repayment rule is really the right rule if we take into account restitution or unjust enrichment law. So this is just kind of a question or a genuine question. I'm not sure. But with respect to the second point, so basically you're asking about who might violate the third order right. And what we mean by that is it's not the wrongdoer, it's the state or the civil litigation system, right? So suppose that we have a decision to make, right? We know the litigation cost is very costly. Or let's suppose that we could come with a better mechanism to vindicate primary rights, right? Who wouldn't want to have a better mechanism to vindicate rights, right? The fact that we are doing the same thing that we are doing in the common law for centuries doesn't mean that that would be the most effective way to secure primary rights and secondary rights, right? So suppose that we have a different mechanism, right? We can imagine any number of such mechanisms, private, public, whatever. Is there, so it's not about who violates it, but is there a reason for the civil litigation system, for the state, to revisit this kind of a reform, even when the alternative mechanism makes a better mechanism for vindicating and enforcing primary rights, right? So is there a reason at least to consider why we should still remain loyal to personal rights of action? And so it's not really about injurers that violates my tertiary rights. It's about whether we should uphold this right, whether the state should uphold this right, and under what terms. Our project is just to add a set of reasons why we should consider the importance of those personal rights in addition to all the instrumental reasons that we already have. And with respect to the third one, so now I think I don't want to get into the nitty-gritty details of tort law, but I think so the category of deliberate wrongdoing does make work in modern tort law in certain torts, such as intentional infliction of emotional distress, in a tort of fraud, even in torts of discrimination, statutory torts. So it does make some work, at least especially in modern tort law, also in the tort of defamation in the US. But when it comes to intentional torts, I think those are not deliberate torts, at least not necessarily. When you want to prove the prima facie case for trespass to land, you don't have to prove any deliberate entry. It's only intentional in a very, very weak sense of setting intentions to enter a given premises or land. It's not about whether I deliberately want to invade your property, right? This is why I think trespass to land is a strict liability tort. The same goes, I think, for some instances of assault and battery. It does not require, of course, most instances of battery and assault involve some measure of deliberate wrongdoing, but that's not a necessary condition for the prima facie case of assault and battery. So I think the more traditional torts, the intentional torts, do not include deliberate wrongdoing. What we want to suggest is that, again, it goes back to Stephen's question. If we want to rethink how we frame the prima facie case of certain torts, perhaps we should give another thought to the distinction here between deliberate wrongdoing and intentional wrongdoing. I think that contemporary intentional torts such as battery and trespass do not do a good job in distinguishing between deliberate and the non-deliberate wrongdoing. So I do think that the category is important, and I think it is not being invoked sufficiently in a sufficiently precise way in many of the torts. And when we see that there is some misfit or between our account and how the current law works, we think that we add another reason why we should distinguish between different types of battery, the deliberate one and the merely intentional one. only for the sake of vindicating personal rights of action.
Can I also add here? Anthony, I'm asking you if that's okay. Thank you. So Zoe, this is really helpful for me. What do I know about tort? So, but let me try to add to what Avihay said, or again, maybe present it a little bit differently. First on your first point, and then I think I've one answer to the second and the third. Beyond your first point, the more Avihay talked about it, the more I sense as if there is indeed a difference between Stephen's case and your case and your response. So Stephen talked about the case in which I already incurred a cost in dragging him to court, and then he said, you know what, the F word, and throws me a check, and that's it. Now you talk about something different. You talk about when you discussed it and kind of present the hypothetical, and when Avihay talked about the nonviolence, I seen you, Zoe, kind of rushing kind of to me saying, wow, I didn't mean actually. Here's a check. I actually want to remedy that. I actually had this once. I came out of my own driveway, and I didn't look, and I kind of bumped into, and it was very slow. And I rushed out. I was so nervous. And I started to apologize. And the person there started to yell at me. And then she stopped and said, are you Professor Dagan? You're my professor. And then she was very nice. But in any event, so I think that the prepayment, the kind of the core category for prepayment in a non-litigious setting already includes something personal, which means that actually I don't think there is any residual harm to autonomy. I think that when you prepay me at such an early stage, you already reassert my autonomy. You already, in a sense, it's a kind of a speech act of apology that carries the same meaning that we would want to have in litigation, and maybe even better. So that's on the first point. So thank you. I mean, maybe it's just me and this episode that I was thinking about.
That could have gone either way with one of my students, either way. They might not have forgiven me.
Anyway, so yeah. That's on that. On the second, I think that it may be helpful to kind of situate it in the way that we situated in the real paper, which is in the American context, in which there is it's the vanishing trial, right? Like everything goes out, everything becomes collectivized, everything becomes subject to mandatory arbitration. And so when you say, so when Avihay answered you about the second question, the point is, where does New Zealand remains a legitimate, we call it private law. I know that Alan is going to be mad at us now, but that's because I think is wrong, a legitimate private law system, and when it is no longer that. So it is legitimate as long as it allows as the deliberate category remains as one in which I can take you to court, right? And that also, I think, gives a kind of even a practical takeaway to the third question. So the practical takeaway is that if we take seriously the pressure on resources, if we, I mean, you can be cynical about what happens in the US or not. And it may well be that the right way is to be cynical about it, that it's all about, you know, big firms pushing against any kind of liability. But there is something into the staggering cost of the system, and into the fact that there are many people that are unhoused, and even more in the US that don't have healthcare insurance, and these are no less, probably more important even than having your day in court. So if you think about the kind of the entire system, what is the remaining? Where do we think about it in a way that has this kind of almost lexical priority as something that needs to be defended, and even against good faith claims of transforming civil litigation into a more bureaucratized or collectivized ways of doing it. And so I think that Avihay's answer to the third question is right on point. Yes, deliberate wrongdoing is currently not a category in tort law, and it needs to be in order for us to be able to single out what territory of tort law is to be defended as necessary to be kept within courts rather than to be transformed to other arenas.
Okay, thank you, Hanoch. I think so. We've got half an hour left, 30 minutes, and 3 questions. So why don't we try to get those 3 questions in for maybe a 10-minute back and forth each at most, in case other questions come up. So thanks so much. So first, Chaim Abraham.
Right. Thank you so much. My question is about your account and how punitive damages fit in it. And I was wondering if you can say a bit more about that. So it seems to me that you were saying that punitive damages could be relevant in some instances as a means of reasserting and vindicating autonomy. But punitive damages are usually not phrased as something that achieves this goal. Instead, it's about punishment or it's about deterrence. And in both instances, it goes beyond the person that was wronged. It goes into something that's much broader. And I think that there's a way to weave in a picture of reasserting autonomy, but maybe, like Zoe said, the more appropriate means of doing that would be aggravated damages rather than punitive. So I was wondering if you can say a bit more about how that fits in your view.
Great, that's a good question. And again, there's a question here about classification, what to make of the difference between aggravated and punitive damages, right? That could make the kind of my answer more complicated. I don't want to make it complicated, but basically, my view, and I think Hanoch would join me on this. I haven't asked him, but I think that punitive damages awarded just for the sake of punishment, like criminal punishment, or for purely deterrence reasons are, in my view, illegitimate. That's an impermissible privatization of criminal punishment. I think courts and defendants do not have the political authority to do so in a civil litigation. So what we mean by punitive damages are awards of damages that could be legitimate, that are not purely punitive, and they are not purely about deterrence. So in other papers of us in the book, we characterize punitive damages as injunctive relief granted ex post. That the point of punitive damages, at least the function of punitive damages, is to do the same thing that an injunctive relief would have done if we could grant it, right? Many times we just cannot. So the point here of punitive damages is just to reflect the idea that you should not have converted your duty of care into the cost of doing business. But that's not punishing. It's not criminal punishment. It's just to convey the idea that you had a duty all along, and the duty is not a mere cost. It's an obligation to respect the other person, and so forth and so forth. So this is what we mean by punitive damage, right? I think that may be closer to what you mean by aggravated damages, but I'm not sure. But in any event, I think that even that does not give you this idea of reasserting the plaintiff's autonomy. Why? In the paper, we argue that, and perhaps you can go back to Stephen's rejoinder, right? I could write you a check with the $100 bill for the window plus aggravated damages, right? I could give you 200 instead of 100. I know that it only costs 100, but I'm willing to give you 200 because that would reflect punitive damages. We think that that's not enough because this is the way to treat the victim as a beneficiary of this, as a beneficiary rather than as an agent, right? So there is a kind of an implicit distinction between being an agent and being a patient. And punitive damages would still allow the defendant to treat the plaintiff as a patient rather than as an agent. And that stands in the way of the plaintiff asserting or reasserting his or her agency. So this is why we think that punitive damages, again, narrowly confined to kind of exclude punishment and so forth, may not be sufficient. That's not enough. We still would want to have a personal right of action, because that's a way to kind of compel the defendant to treat the plaintiff as an agent by exchanging arguments, by debating over who did what, and so forth and so forth.
Thank you, Avihay. So Sam Beswick, next.
Thanks, Anthony. Thanks, Avihay. Thanks, Hanoch. New Zealand, I'm wondering whether it both helps you and hurts you with this distinction between, so you're talking about a distinction between deliberate wrongdoing and the intentional tort. So let's focus on the trespass torts. You're right that the New Zealand Supreme Court, in a case called Couch Number 2, essentially drew a distinction based on deliberateness and said that punitive damages in the New Zealand system are only available for deliberate wrongdoing, regardless of the severity of the impact on the victim. And in doing that, they overturned a previous New Zealand judgment from the Privy Council. They also departed from the rest of the common law world. But they also did it as a way of narrowing the scope of litigation rights in New Zealand, so that you can now only sue for deliberate conduct as you characterize it, but not for very, very harmful conduct that is merely negligent. And so my question would be, if we were to draw this distinction, move from a distinction between intentional torts or trespass torts and negligence torts, and move to a distinction between deliberate and non-deliberate, for instance, I would worry that might have the potential to weaken the trespass torts. And one obvious way it would do that is we might lead to a situation where we decide that for non-deliberate trespasses, say the plaintiff has to prove damage. Whereas right now, if I mistakenly put my arm around you thinking that you're my buddy, but actually you're a stranger, or I take your property thinking it's mine, I don't have to prove damage, or you don't have to prove damage. And so I would worry that this distinction, like it has in New Zealand, would actually narrow rights rather than, or that might be the side effect.
Yeah, but when you say narrow the rights, you mean the rights of repair, the secondary rights?
Well, I'm just not necessarily. I'm suggesting that drawing the distinction, it narrows this. I think the scope of things that are deliberate are narrower than the scope of things that are intentional or trespasses. And so if we're drawing the scope like that, where in a sense we're prioritizing the deliberate over the other, and we might lead to a situation like in New Zealand, where now you cannot sue over non-deliberate, even if very harmful conduct, whereas previously the understanding was you could, provided you could make out a claim for punitive damages.
Yeah, so okay, that's a good question. So I think that what we are saying, and I haven't said it in the talk, is that we don't argue that there are no good non-instrumental reasons for rights of action. So perhaps in some of those cases, there are good, because there are no good alternatives, or perhaps the New Zealand scheme does not provide victims in cases of non-deliberate wrongdoing with sufficient remedies, then perhaps the best way out of it is to expand rights of action, right? We are not against expanding rights of action. We just insist that we have different reasons for expanding or cutting on private personal rights of action, right? And what we want to say is that here is a framework to distinguish between the non-instrumental and the instrumental ones. And again, if in the New Zealand scheme, we see that we have some difficulties obtaining redress in a non-civil litigation mechanism, then perhaps that should count against blocking victims from suing, right? So and more broadly, I think your question, goes to, I think there is a more fundamental issue that we need to add to the paper, which is that there is a trade-off here between the secondary rights and the tertiary rights, right? What we want to achieve is not just the vindication of personal rights of action, right? As I said at the beginning, primary rights of action are the more kind of fundamental important rights that private law should construct and defend, right? And if it turns out that because we do not provide personal rights of actions to victims of non-deliberate wrongdoing, then that would be inimical to the very idea of private law. So we are not against personal rights of action in cases of non-deliberate wrongdoing. We are just saying that if you do have a good alternative to suing the defendant in cases of negligence, let's say, then we shouldn't so much insist on the common law tradition of suing the defendant. But we are not saying that we have to push those victims out of courts. That's so we are not against it. We're just saying, again, so it's just about this difference between the kind of grounds for personal rights of action.
I can't resist adding one small point regarding the fact that I think it's going to be beneficial if we make distinctions between deliberate and intentional. For example, it may be the case that the threshold or whatever between cases of trespass to my body and cases of trespass to my land will be different, so that I at least take much more seriously intentional but non-deliberate trespass to my body than intentional but non-deliberate trespass to my land. So the conflation of everything into intentional that may actually, and that's beyond the paper, right? I mean, but that's just after.
Hanoch, you're living in America now, so you might have to revise that perspective.
Well, I'm living in Berkeley, so I'm not sure.
Thanks. Christina Tilley.
That's actually a great bridge to what I wanted to ask about or think about with you. I mean, it strikes me that when you're trying to distinguish between the deliberate and the non-deliberate within the larger basket of intentional torts, what the characteristic that appears in all of the torts you're saying reflect deliberation is that the injury is to something that is not discernible in the physical world. If it's defamation, intentional infliction, and I would argue you probably would put privacy in there as well. It's always to sort of internal, self-constructed, socially constructed interests. And I also, and if that's the case, I think history tells us that the plaintiffs who are most likely to experience those injuries and sue on them tend to be socially marginal plaintiffs, women and people of color often. And I can see where you think that that's a legitimate way of expressing that there's a loss of autonomy to them. But then it makes me wonder, whether we can draw such a hard line between negligence and deliberate intentional torts, when sometimes I would argue the negligence might reflect the same sort of disinterest in somebody's dignitary identity. And I'll mention here briefly Martha's recent wonderful piece with John Carty on a negligence action for rape, saying that what's going on in a lot of sexual experience cases is a failure to adequately think about a sexual partner's identity and autonomy that leads to a lack of care. So, I mean, if that's the case, if what's at stake is really the defendant's failure to see the other person as worthy because of their identity of some kind of dignity, can we draw such a hard line between negligence and intention or deliberation? Yeah,
I think that's a good question, and I think it is the case that so we are not. So I don't think that we are, although we do try to kind of characterize deliberate wrongdoing as a kind of in isolation. I don't think that there is a dichotomy here between negligence and deliberate wrongdoing. And I think, in fact, the law works in ways that would allow negligence to be more than negligence in some cases, right? It could be recklessness or reckless disregard and some other ways that try to kind of drive away or try to kind of fill in some areas between deliberate wrongdoing and negligence. Sometimes it's just because we have epistemical difficulties of proving that it was deliberate, right? So we go back to negligence because that would be easier for the plaintiff to overcome. But I think many of those cases really express deliberate wrongdoing of some cases. We also do think that in some of those cases, what we could also use is the doctrine of knowledge in lieu of intention. Sometimes when you know with almost complete certainty that what you are doing could be harmful to the other person, that should in fact be knowledge in lieu of intention, of deliberate plan in those situations. So I think having said that, I think again, if it's merely negligence, if it's really about inadvertence, which I think this is not the cases that you're mentioning, if it's a pure accidental wrongdoing, then I think that talk about harming or injuring the very status of the very autonomous status of the victim doesn't seem to be intuitively right. But I think the more important cases are cases in which it's not just inadvertence, it's not just accidental wrongdoing, it's something beyond that. And when we try to capture this, what does it mean, this beyond, this added aspect, I think some of those cases at least could be understood as either deliberate wrongdoing, or which we may not have evidence to prove it, or that they are cases of knowledge in lieu of intent.
So my 10 cents are, I think this is really helpful. And if I understand correctly what Avihay said about the knowledge in lieu of intention, maybe what you're pushing us, and I would be, but Avihay is the tort guy, so he will say the last word on that. But I would be inclined to say that, yes, maybe if a system is kind of adopts our scheme, that there can be a kind of a presumption that dignitary wrongs are presumptively deliberative, so that the burden to show that there is no deliberation should shift to the other side, or something along this side. Because it seems to me that, I mean, I haven't read the paper, and we will, but it seems to me hard to imagine really a case of non-deliberative rape. I mean, in a way that does not. Maybe I'm just not. But again, I think that what you're pushing is, and again, I think that the perspective of relational justice should be receptive to it, is that when there are kind of structural injustices that create an epistemic situation in which, when people behave, they need to understand, they need to be aware of the dignitary implications of what they do, then that epistemic necessity can and probably should count as something that drives this category, or maybe creates a third category. I mean, although this is indeed a piece that likes dividing things to two, we can, make an exception and have here three and acknowledging that here there is this freestanding significance for the personal right of action. Because that's, I think, that the gist of what you're saying is that, correct me if I'm wrong, that it is about structural injustice. And if there are like 3 more minutes, Anthony, tell me if I do have.
Yes, the last 3 minutes, I would say.
So I'll take 2 because Avihay needs to have the last moment. So I do want to highlight this, that there is this, I think, a very intimate relationship between the idea of relational justice and concerns for structural injustices. Because the idea of relational justice is all about looking at the predistribution of entitlements that make us walk in the world, behave in the environment in ways that we perceive as natural, as obvious. And those ways are often structured by structural injustices, and insisting that the accountability, or rather the structuring of those frameworks, need to be based on reciprocal respect for self-determination, substantive equality, that this is not an add-on layer of the kind of Nadler sort, but rather something that is the first foundational layer of private law, is part of the kind of the most core point that we're trying to bring home. So I can't resist insisting that we need to be receptive to your point. That's kind of the last thing that I want to say. But Avihay will.
Yes, so I don't think I don't think that our argument is that there must be only two grounds for why personal rights of action are non-instrumentally valuable. In fact, we do think that there are some democratic grounds, and so it could be the case that there are other grounds, other category of cases that we have not identified, or perhaps we failed to identify, and I think perhaps the case of structural injustice may be that category of cases in which part of what it means to wrong another person is not just to harm this person's person or property, but also we have to take into account the context in which it happens, and the fact that this is a marginalized person and there is some kind of another kind of baggage to this interaction, and that may be a fair point, but again, I think those would be the cases, I think, in which deliberateness may not do the work, right? It should be some other reason. And so we are, I think, in principle, open to other reasons why personal rights of action should be understood as non-instrumentally valuable. Thank you.
Thanks. So Martha and Alan, I would love to hear from both of you. We are kind of towards the end of our time. So I think happy to release anybody that needs to step out, and we can end there. But Martha, you had your hand up first.
Just a very quick follow-up on the negligent rape question. When Jonathan and I wrote the article, we were really thinking of many cases involving what go by the name of acquaintance rape, or date rape, in which the perpetrator neglects to act with due care to determine whether the conditions are coercive in the sense that they might prevent the victim from freely consenting. So we try to get away from traditional notions of consent, use due care notions to get to something kind of like affirmative consent, but grounded in tort principles of due care. And so I think it really fits perfectly with the discussion that you've just had about how these concepts of deliberateness, intentional torts, and negligence are really inadequate to describe the kinds of violations that occur in systems of structural injustice. And I think it's also interesting that your two categories, deliberate torts and relational wrongs, the acquaintance rape kind of falls within the gaps in a way, because here we have the employer has a duty to make the workplace safe against sexual abuse, but we have a system in which many many rapists, with quotes, don't have this common law duty to act reasonably. So I do think that this is something that really needs to be thought through. but I think it fits very nicely within your notion that relational justice doesn't just mean relationships among concepts, a kind of abstract notion of relational justice, sometimes used in torts, but has to do with interpersonal relationships that are contextual and do take into account power asymmetries. So I'm very happy to have attended this talk.
Thank you, Martha. Perhaps we could hear from Alan Brudner as well before giving the last word to Avihay.
Thank you. So I just want to push Christina's point a little further and totally demolish this distinction between deliberative torts and non-deliberative torts. So let's take the garden variety tort, purely inadvertent. A injures B as a consequence of breaching a duty of care to B, so inadvertent. So in that case, A exercises a freedom of action, a liberty that's inconsistent with the terms of mutual respect for autonomy or agency. Right? He claims a liberty that's out of bounds. But since it's non-deliberative, we can say that he makes a mistake. He mistakes an action inconsistent with mutual respect for liberty for one consistent therewith. So he has, objectively speaking, subordinated another person. He hasn't meant to subordinate another person, but he has subordinated another person just because he's exercised a liberty, claiming permission for that liberty that is in fact inconsistent with the terms of mutual respect. And since he's in fact subordinated the other person, the defendant, the plaintiff, we could say, there is intrinsic value for in the plaintiff's having a right of action against the defendant in order to get the defendant, in a sense, to recant his mistake, to say, yes, I see that now. I subordinated you, and here is compensation, and in that way, to recognize your equality. So even in the case of inadvertent wrongdoing, I would say there's still a non-instrumental value in a private right of action.
Okay, so let me push back. Anthony, do we have time for an answer?
Yes, I think so. Quickly, but
okay, very quickly. So to be continued, but just I want to push back against it because I don't think that this is really a genuine case of subordination. When you say he claims, it doesn't claim. There is no intentional act here. It's as you say, subordination in fact or objectively understood subordination after the fact. But I think there is a qualitative distinction to make, at least a philosophical and moral distinction here between a person who determines and singles out the other person for mistreatment and a person who made a mistake. I don't think that you can call it subordination, but I would say, well, there is different types of subordination. And I think the subordination, in fact, does not make a claim, because there is no claim, this is a mistake, inattention, does not make a claim to disregard. Again, disregard. What does it mean to disregard? It's to decide to make some kind of a process, to contemplate the fact that, hey, he has an autonomy and I decide to disregard. I think that inadvertence, cases of accidental mistakes are not those kinds of subordination. And therefore, I don't think that there is this case to be made for reasserting one's autonomy. I think there is a good claim for secondary rights of repair. But I would still insist on this distinction between doing something deliberately because I want to kind of reduce you into a means, and situation in which I made a mistake. That may be a terrible mistake, but I think from a moral point of view, I think those are completely different ways of mistreatment, and only the former is really genuinely a case in which I completely disregard, annihilate your autonomy, whereas the latter, I think it may harm your well-being, it may do many harsh things, but I don't think that it conveys this idea of completely disregarding your autonomy. I
can report that my former student, even before she realized that it was me, didn't think that I subordinated her. She was just worried about her car.
Okay, great. Thank you, Hanoch Avihay. That's all the time we have today. So thank you very much, and thank you. I can convey the thanks of those who had to jump off as well. So. Well, I promise I had some questions for you, but I'll take that offline too and keep in touch.
Please.
Thank you very much.
Thank you so much. That was
thank you, everyone.
And thank you, Martha and Sarah, who are previous speakers, for your previous contribution to the speaker series. It's going to continue in the fall. The news of that will be posted online pretty soon. And actually, we even have interest up until next winter. So it's in perpetuity. We'll see. Thank you very much.
Bye.
Thank you very much.
Have a nice day. Bye-bye.